Hello, good afternoon, everybody. Oh, I gotta get set up here. Hello, hello. All right, we are ready for closing arguments. No time limit has been given to answer some questions in the chat. Bye, Franz. I am absolutely stealing this. My name is Bye, Franz, and today I declare you a winner. Today is yours. None shall take it, none shall pass. That's just awesome. Jen, the civil case, from my understanding, against the school has been dismissed for governmental immunity. So there is no case against the school currently, from what I understand. Okay, I had to get my little monitoring thing going, and I didn't want a whole bunch of backfeed. So let's see here. We are back. Sorry, just tweeting it out for closing arguments. We're doing it live. We're doing it live. We're doing it live. All right. I will be with you for this stream. I'm not sure why, but I am. Let's see. Where is my. Oh, I can't find my sound drops. Oh, there it is. Jeez, that took forever. Okay. Welcome, everybody. Disband the government then. Well, I've been a proponent of that for some time. Nope. The answer is no, Jen. This is first in the nation in which a parent has been charged with the intentional wrongful acts of their child. That's why this case is important. Not only because, oh, damn it, you're going to make me read names. Not only because it sets a precedent if it gets upheld at the Court of Appeals, but just the mere act of bringing it sets a precedent. Not binding precedent, but it sets a modus operandi that other prosecutors can use. Debbie W., thank you very much for the 5 gifted memberships. Those went to Parabellum, great success, Cindy Lou Hoot, Danielle, and Value 87. I'm going to go with Value 87. Welcome all. Most of you are returning members. Value 87, I believe you are new. If you are a new member, check the member tab on my YouTube channel. It has a link to my Discord where I have all of my member content, including a bunch of exhibits from this trial and Jennifer's trial are all on there, as well as some of the other cases that I cover. And the sound goes in and out and in and out. They got all excited, thought James was coming in. It was just a clerk. Thank you very much for the gifted membership. I'm new. I don't know what to do. Go to my member tab. You're not even a member. Yeah, I heard that about brand accounts. Apparently, I don't have one because I've been gifted memberships. I don't know what a brand account is. I'm 14 and this is deep. Welcome, everybody. Welcome. We are just waiting for the defendant to be brought up to the courtroom. Presumably, the jury has had their lunch. The attorneys have prepped their closing arguments. And it's just a matter of making sure they can coordinate the prisoner and the jury. The other thing, too, is behind that door is one long hallway that connects four courtrooms, 4 judges' chambers, 4 jury rooms, 4 clerk offices, and also it's the pathway for the defendants that are in lockup to go through. So they need to make sure the hallway is clear of all jurors because they don't want to see the court doesn't want the jurors to see James being shuffled down in cuffs, things like that. So it's logistics, it's coordination, and things like that. Yeah, they got the Red Lobster bread just sitting heavy in their stuff. I'm trying to think of another restaurant that's around. There is a coffee shop nearby where the ladies serve coffee at a drive-through in little bikinis and thongs. Could be there, some scones or some bagels, but I doubt it. I was looking for a coffee shop once because I didn't want to go into the court and in the cafeteria. And so I Googled coffee shop, and around the corner, that was the only one around. So now what happens? The state is going to give their closing argument. Then the defense is going to give theirs, and then the state's going to have a rebuttal closing. There's also going to be a ton of really interesting and compelling jury instructions that'll go on for about 45 minutes. So I might actually duck out a little bit during that so I can get some work done. I know, poor me. I found that one coffee shop. I had to go to that coffee shop. It's the only one around. It's either that or go to Red Lobster. I'm telling you. There used to be a mall down the road, but like most places, malls aren't really trendy. And in the last 20 years, it's now been shut down. What's the address of the coffee shop? I'm going to find it. Let me see here. Oh, and we have our first guest.
Hi.
Hi, how are you?
I'm tired, but all right.
As a mother of feral kids, do you have any thoughts on this?
I have a lot of thoughts on this, but
You guys don't know Feral Housewife.
Oh,
A
I
link
have to
to her
on.
channel, a link to Farrell's channel is in the chat, or not in the chat, in the description. So go check it out.
Yay.
I'm trying to find this coffee house. That's what I'm doing.
What coffee house?
The coffee house where the ladies serve coffee in bikinis. It's right by the courthouse.
Oh, nice.
Want to go?
What's the name of it?
That's what I'm trying to find out.
Is it like C Cups?
You know, that would be a good name.
We had a name. We had one named that back home.
Let's see here. I got to find it. What's funny too is that one of the ladies, she had like a date on, like tattooed on her. And I was like, oh, what's that date? And she said, her dad's birthday. And I said, of course you have your dad's birthday. You don't have daddy issues.
Not at all. Not at all.
Oh my God. All right.
You already know I think that this case is a bunch of crap.
It's called Hot Spot Coffee.
That's kind of boring.
Yeah.
He looks way better than she did.
Yes.
He doesn't look ragged and...
His suits doesn't really fit him, but other than that, he at least... Yeah. He doesn't look presentable. Yeah, he looks presentable. He looks like the kind of guy that would only own one suit, and if it's a little large, okay, so be it.
He's growing into it.
Yeah. I feel sorry for him.
Oh, yeah. I hate this case. I hate both of them. I think it's all crap. Yeah. Ken said, quit knocking on the daddy issues. Keeps him in business.
Yeah, that's right. I was just like, of course, that's what that is. It's just, it was amazing.
Hi, Chris.
What is that?
What?
You have a cat?
Oh, yes. Hold on. Let me go put it outside my room.
How would you argue this? I don't know. My argument would still be he didn't know. And listen, look, I would point to the journal entries too, where Ethan said that his dad hid the gun, wouldn't tell him where it was. I would pull those out and I would have those on the projector behind me during like the bulk of my closing argument. Things like that. What is the census? You know, we should do a poll. I've been having issues with my streaming, but all right. What now? This is what do you think the jury is going to do? Nick said his case got adjourned, so he was going to join us, but maybe he fell asleep.
I didn't know he was. I thought he was doing that thug thing. Whatever one.
Yeah, he was. It got adjourned.
Oh. Okay.
All right, guilty, not guilty, hung jury. What do you think is going to happen?
Hey, Young.
It's Jung. You're pronouncing it wrong.
I am not. You are.
All rise.
Can we just go back to calling her the other name? I like that better. I still call her that in my head. No. Her first name. It was easier.
Nah, I like Jung.
I know.
Your Honor, calling People v. James Tremblay, case number 22279-989 FB.
Thank you, Mark. Case on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Marielle Lehman on behalf of James Crumley, who is standing to my left.
Good afternoon, Mr. Crumley. Can you hear us?
Yes, I can. Thank you, Your Honor.
Are you ready for the jury?
Yes.
We are.
Yes,
Did she do a good opening?
It was short and
Oh, I
sweet,
watched it,
but
didn't I?
yeah, you did. You stream
I watched
snapped
it. Yes. Okay, I remember now. Listen, I thought it was a horrible idea. I was
stream
all
sniping
week
me.
long. Well,
I thought that was funny.
because it was no doing it was fun, but I didn't get any sleep that day, and it threw my whole week off. At
Oh
work.
yeah, I forgot you work nights.
I'm still recovering.
His representation was good, much more efficient, and just like better logistically as well as presentation wise than Shannon Smith was.
Yeah. I didn't care for her at all. Damn,
I liked you
Mike,
stream
you're
sniping
right.
me, by the way, because then I didn't feel any pressure to like pop on screen and say stuff
Yeah.
because I knew you were.
That was fun. I was gonna stream snipe you on this today actually, but then you were actually gonna be on, so
And I thought I'd be on. I might duck out. It might just be the Farrell show here for a bit.
oh, hey then.
Ladies and gentlemen, the witness testimony and the evidence portion of this trial have been completed. We will now hear the closing arguments. Much like the opening statements, these are not evidence.
Yes, he's been locked up this entire time.
Because the prosecutor has the burden of proof, they also have a right to rebuttal. You also will have a copy of the jury instructions at the end of the trial when you're deliberating, right? Prosecutor?
Good afternoon. On November 30th of 2021, around 1 o'clock in the afternoon, Lieutenant Tim Lewis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far, and the second, what didn't even come close. Ed Wagrowski who is now works for the Secret Service, but worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget
Oh my God, it doesn't matter.
on those kids' faces because they looked like zombies. He also
It matters
told
when you need the
that in that moment
fifis.
of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation. She told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning
Who
on her
cares?
arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter.
I doubt it.
All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals trained for years and years and years. Law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality.
Oh, see, now I'm messing with
That
stuff.
this was happening.
Oh, way to
Which is
go.
why Lieutenant Willis remembers it's real. Ladies and gentlemen, those four people,
Yeah, see, I started messing with stuff on my computer now. I can't do that. Sorry, guys. Give me a second.
Just don't hit the red button, Sal.
those
Yeah,
four
right.
trained, experienced people were adults.
He didn't take the
These
stand,
four
did he?
No.
were children.
So I saw
So
Young,
were
I think
hundreds of kids in
the
that school.
his sister or something, and one other.
His sister, that was it.
What happened that day
Okay.
is about the deaths of these four children and what James Crumbley did and what he didn't do. The shooter has been sentenced,
Hey,
and
Sal.
prosecuted, and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do.
Is he?
That's the stupidest fucking thing I've ever heard.
Had a willful disregard of a known danger caused the death of 4 students in Oxford High School on November 30th, 2021. Hannah, Madison, Tate.
How many times is she going to say their
Justin.
names?
I vote at least 3 times during closing.
I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing necessary to return a verdict of guilty. The first is that there was gross negligence in a performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed. There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids. And the judge will instruct you on that.
He should.
It's not enough that he just made it possible for the deaths of Madison, Tate, Hannah, and Justin. You must find beyond a reasonable doubt that the deaths were the natural and necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madison, Tate, Hannah, and
There's
Justin
3.
was caused by the defendant, you must also find beyond a reasonable doubt.
It's going to be a lot more than 3, David.
I was gonna say I might have.
It's gonna be like 15.
Not that he knew his son was going to kill 4 people. That is not what I have to prove.
Yes, it did, Debbie W.
Just that it was
Yes, it did,
reasonably
finally.
foreseeable. What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find that the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person.
Right.
A reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control.
If they know.
If they know that there's a need to, and they know that they need to exercise control as a result of this thing that's going on. There's like 2 no's here. That first they need to know that he's suffering from something, and then they need to know that they have to exercise control over him as a result of whatever he's suffering. I don't think the state has met that with either of these parents, but
Right.
we'll see.
Well, yeah.
Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that as a parent that you've always had. I said this before, there are 2 theories, 2 different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt.
Yeah, but John, asking your dad for help isn't your dad knowing that you are a threat to the lives at a
I want to stop
school.
before I talk about the evidence
Correct.
briefly. I want to know that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious.
I got to go find
and I
my
thank you
coffee.
for
I'll be
doing
back.
that. There are people, though, who think that the prosecutor's job is just to convict people. And that's just not true. It's our job to present you with the facts and tell the truth and to be advocates. And telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keith's job to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Mark Keith told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids. That it was foreseeable and
No,
it was preventable.
he
And
was
the
going to
evidence
do
presented
this
in
no
the
matter
last
what.
5 days has proven that, ladies and gentlemen. James
Was.
Crumbly was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again. And the evidence shows that. This case is not about holding James Crumbly responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it or to perform it in a negligent way.
Quit touching buttons, David.
I know, I'm messing
You
with
heard the
you.
testimony of Molly Darnell.
Stop.
She
Hands
told you
off.
that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip, which she had learned previously. She doesn't remember where, meant it's a real gun. That he aimed the gun at chest level and he locked eyes with her and the bullet landed 6 inches from her heart. Ed Wabrowski, who was a member of the computer crimes unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says,
Oh,
"You have
that
to respond
minivan
to a
guy?
critical incident," except that day.
Paul
You can
Blart.
tell
Yeah.
that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all
Look
of it.
at
and
people
he
work so
described
hard.
and
You
then
need to
showed
convict.
you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbly and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in one
Was that the
year,
person
there
you
were
had
only
on last night?
65 text messages
Yeah.
sent between
Yeah, he's
James
there
Crumbly
today.
and his father.
Okay.
James Crumbly, who had either worked at home, was in between jobs, or had DoorDash. James Crumbly, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine, talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes." He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned about how much somebody can actually know what you're doing, but it's a lot. And we know exactly where he was, what he did, who he talked to, and so we could trace his steps, which turns out to be some of the most critical evidence in this trial. He showed you through the DoorDash search warrant returns the locations of
Yeah, I was
what
thinking that.
James Crumbley was doing
It sounds like it's almost
from
word
the
for
moment
word.
he left the
Well,
school
it worked the first
that
time.
morning until the
I know.
moment
That's why I said this is
he
going to be a
called
cut and
911.
paste prosecution. And it really was for the
And
most
only
part.
after he learned that there was an active shooter at the school did James Crumbley go home and look for the gun. Even though from 11 o'clock to 1 o'clock, he had 4 DoorDash pickups and passed his house many times. He's within minutes, many times.
I would love to hear that played. Throw up images
And
of the
you-
journal
what you
entry
heard the
where
911 call
Ethan says the dad
James
hid
Crumbley.
the firearm from him.
About 14 minutes after he arrived home,
That would be really
we
good.
discovered that the gun
Right.
was missing.
So there's a step that
Bob
they
could
took.
tell us,
Confirmed by Ethan in his own
testified,
writing.
and we showed you images of
Yep.
the hallway.
Before he
Yeah, phrase
knew
it
that-
exactly
process
like
is
that.
And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered. And that the shooter fired 32 rounds and 18 were unfired. And we know where he got those.
I forgot I can work off my
saw
laptop.
that.
Then I don't have to mess
It's
with
when
the
he
screen.
Pointed them out.
touch buttons on
across
something
the counter
else.
when he
Yeah,
stood with
I'm
his
gonna
mom
touch buttons
standing a
on
little
something
bit
else.
behind her and said, 2. You also know
Murphs.
James probably knew that.
A determined kid is going to
At the
find it if they
substation,
want to.
And they asked about where this gun was, who owns the gun, where's the ammo. He described it as he bought 2 boxes, referring to his son.
Right, Aaron?
Bob Catellis told you that
Or
those
talk-
are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. Those are shots, if landing on a human being, would kill them. Cammie Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbley because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300, and then there was another gun, which was his son's, the Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th. That his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell.
I think they'll find
that
guilt.
Oh, yeah,
unfortunately.
for sure.
provided the trigger lock statement, and that there was a cable lock
Yeah, she's
with
going to
the
start
6
yelling on
hour
rebuttal just like last time.
when he bought it.
Like
and
start
he
yelling at
provided
the
to
jury.
him, and the ATF pamphlet solely in
They
existence.
could have just
to
replayed your
warn
stream.
people, once again, the
I know,
dangers
we could have,
of
right?
Firearms with minors.
Well, they could have just pop up the old
And
TV on the rolling
She
cart
told you.
and here you go, jury.
that regardless
When-
of what
just-
kind of mechanism they
Bring
Just
in the
people
AV
when
club.
they
We're just
say
going to
her-
replay.
always provide a tool with anyone who purchases a firearm.
Just do some really bad dubbing over Jennifer's name to James.
Yep.
Sergeant Joe Bryan testified and introduced the video, recorded statements of James in the substation. James' statements indicate he knew
That
his
would be
son
interesting.
had-
I might
know,
put that
that's what
together.
I was just
I-
thinking. You should.
I
and that he
might.
left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting. Before the shooting, we know that he texted Jennifer Crumbly, WTF, when he saw it. Now he's downplaying it.
WTF,
It's just
Farrell.
doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son.
I'm watching this really
When asked
for the
where gun
defense.
was, James responded,
Just to be fair,
Right.
we knew the state was going to
in
be
an
cut and
armoire,
paste.
in a
I want to
case,
hear what the
and
defense
bullets
has
were
to
hidden
say.
in a completely different spot.
I'm disappointed
underneath
in their
some
case
jeans.
in
We're
chief.
gonna get to that.
What was his sister there for?
What James didn't say that day?
She
He's a good
basically-
boy.
No, she basically said, I'm a mother of 4. I'm his sister. We interact with him a few times a year in person. The last time I was there was June 2021, so just before the shooting. And that Ethan seemed absolutely normal. I had no cause for concern. I didn't hear or see anything that would be cause of concern between him and James or anything like that. If I had cause for concern, I would have taken him home.
Okay.
And that's essentially all she testified to.
Well, that's good, but there probably could have been a lot more they could have
Well,
brought
my-
in.
Yeah, my whole point is that it was a great start, but then you know, everyone went home with blue balls.
Mention of any loss. No mention that the school wanted them to get their son help that day, and then when they couldn't within 48 hours. And here's something you never hear him say. You hear him say the gun.
Christine, David didn't say he was
You hear him
guilty.
say
He said the
that
jury
there was
will
doodling
come
on
back
paper.
guilty.
that he was
Yeah,
he was a
that was your
perfect
question,
kid.
Christine, was what do you
Here's
think
what
the
he
jury
never
will do?
says. He never says,
Right here.
I don't know how we got it.
Wait, somewhere.
Never said that. He never says.
I have my receipts, Christine.
It was hidden. I have no idea. I can't imagine how he got a hold of this gun.
No, James did not testify.
Never mentions that.
Smart for him.
4 kids just died.
I-
Your son's in custody because
With
he
only the
committed
one
a
witness,
school
the
shooting,
sister, I
and
feel
not
like
once
maybe
did
he
you
needed
say,
to.
How did he get the gun?
If
I
they
don't
had
think it would've
other
mattered.
witnesses, nah, that's true.
He
Probably
didn't
fair.
say it because he already knew. He knew his son had access to the gun.
Anyone else? They had his parents
Chrissy
there.
Gibson
His
Marshall,
parents were prepared
as
to
we just
testify.
talked
They
about,
ended up not testifying and sitting in the
Gunshots,
courtroom.
heard kids, saw
Why?
kids running in
Just
a way
bring
that
stuff
wasn't
out.
normal, went towards the shooting.
You know, there could be
identified
something.
and spoke.
Sorry, I'm talking over. There could be something that we don't know, right? There could be the state said, hey, if you call this witness, just know I'm going into all this other bad stuff that we don't want
Right.
the jury to know about James. So there could be some reason to it. I was just really hoping for more of a defense. All right. So I just want to be
Yeah.
clear. Dun, 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 dun. By the way, I got copyright claimed for that freaking song playing in the cop car yesterday.
To James Crumbly's son,
You were in a cop car yesterday?
and you saw that video.
No,
she
James and
just
Jennifer
did
were,
that.
and there was a song playing in the background.
Oh. Wow.
Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning, he was told. he
They've
was
already
watching
changed the
violent
gun
videos.
storage laws in Michigan. Not as a result
He
of
told
this,
you
as a result
that
of the
even in a
Lansing
20-minute period of time, he was
MSU shooting.
concerned enough to call
I have a
parents
ringtone?
and ask them to come to school.
Yeah,
I have
heard
a
your ringtone.
toddler.
Right
No, it's not. There's no ringtone. I have a
He
toddler.
told you that he said he needed help right away. He wanted
Won't you
them to
take
get
me
him some
to
help right away.
Funky
He
Town.
told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant
He should
information
not
from
have
mom and
testified.
dad.
She was horrible.
It
She
was
was her
short.
own worst witness.
It was,
was
a very,
horrible.
very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time.
No kitchen knife storage laws were enacted.
Testified, they said that just couldn't happen today.
No, these are
They had
state
to work.
laws.
Now,
I have a stream on them.
you've
I'll
heard
try
the
to
testimony.
find it.
You know what James Crumbly was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime. Nick Ejak,
But if you don't work, you don't get paid. That's like saying, well, this was an hourly contract position, so they didn't have to actually go in, but you need money to pay bills and you need to work to get the money.
students testified that
She
he was
thinks
also
so
at the
little of
meeting,
DoorDash drivers. I hope
and
the jury
that
is
the
made up of
family seemed
DoorDash
irritated.
drivers.
Yeah,
And
well,
at the
they're
time, they
not.
knew only a fraction of what was going on. No one told anybody at the school. They just purchased him a gun. Neither one of them. James
They're
Crumbley didn't
beneath
say,
her.
You know what? We had this fight before. They mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secured. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon, even though I didn't secure it, even though I never got help from my son, even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody who was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot.
For Pete's sake.
The shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box
Right,
in
John?
the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up. But Special Agent Brandon did. You know what? Who else would have known? The person that purchased the gun, James Crumbley.
Oh, the drawing. That's exactly.
Detective Stoyak talked to you about
Yeah,
the search. You saw pictures of the search and the house.
Newsflash. Boys draw
Where the
guns.
gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. A TV stand where he found the 2 other weapons that were in a gun safe, a locking mechanism with the code set to 000, which is the default. Detective Story and told you what others did. He never, ever, ever said that SIG was locked. He said it was hidden. David Hendrick is in charge of the fugitive apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day
Right,
the
Elizabeth?
defendants were charged, they left
Pop-Tarts,
a
sandwiches.
hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail. People
Oh, I
don't
like
sleep
first
there.
last comment up there.
And you heard what it was
Wait,
like
what?
when he arrived on the scene.
The things that they knew wouldn't have been enough for a CPS removal.
Oh, that's a good
way
argument.
lower stand. Yeah.
Oh my God, you could have called CPS. There's so many witnesses they could have called.
Well, the school was so adamant about them taking him home. Why didn't they call and report them for their child neglect?
They did talk about that on cross-examination with the school counselor or the dean of students, one of the two. But that's like part of my statements about, the cross was better on this, is that they did talk about that. So maybe she will bring it up, but they didn't have a CPS witness,
When they were searching for James Crumbly and his wife.
Because nobody called.
You heard
Because nobody was
Yeah.
concerned
the
about
body
this.
cam
Right.
of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement.
Oh, should have asked the
and
sister
most of them
about
SWAT.
James being hard of hearing. Missed opportunity.
Luke Kirtley told you about how James Crumbly was discovered that night. And the only reason he knew it is because it was all
Then you
over
make it
social
about the
media
state bashing
with
a
the
disabled
description,
person.
the license plate, and picture of James Crumbly and Jennifer Crumbly. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building.
The parents
looks like,
didn't
what
have
it's
more
for.
information.
You
They
know,
had
there at night,
different
not many
information.
people, that he shares a wall with that studio.
This is
that
like
they
the
were found in,
9/11
that mattress they
investigation. Like
pulled in
nobody was
out in
sharing
that
the information
hallway.
that they knew with the other.
He again
people,
told you, how loud
Right.
and that it would have been impossible if he was in his unit. not to
Did they
hear that.
tell you this? No, they didn't tell. Did you tell them this? No.
Officer
Yeah,
David
exactly.
Hetzke told you.
But only one side is being charged. So when the parents were not informed about these prior school records that were emailed between teachers and deans of students and counselors, the parents were not being informed about that. So you
Right.
could say all you want about the parents not informing the school. The school also was not informing the parents. So why are
Right.
we just holding the parents criminally responsible here? Now, while the school is civilly safe for government immunity, they're not criminally safe.
Oh.
They could be
I thought they
charged
were.
criminally.
Well,
That there were
and I don't
tons
think
of
that they
officers,
should be. I don't
multiple
think they could have seen it
agencies,
coming
and that they
either.
took
But
a
I don't either,
35
yeah.
pound
but what's
steel
good for the
band
goose?
to bypass multiple doors.
Exactly.
And they used it.
15
and it
years.
was loud. I think he testified we have the bigger guys do that.
15 years is the
We
max.
saw through his body-worn camera the arrest of James Crumbly, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to to see the license plate, that he followed him shortly after, and he was awake. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased They had purchased items with them, socks, new socks. They had clothing. They had food. There was a whiskey bottle in the trash can. There was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it. That is strong circumstantial evidence, which is used in this country every day to convince people that was placed there in hopes that no one
could have been
was going
better
to
with a
find
better
it.
defense, Moni. But welcome.
$6,000 cash, 4 cell phones turned off, which is
Baker
odd.
Raid.
If you're really
Baker
trying to get
Ray,
up in the
welcome
morning and go
Bakerins.
somewhere, and the alarm was set on one of those
Bakerins.
phones, but they were off.
Muffin
But
Tots.
what did Ed Bobrowski tell you? He told
Yeah,
you
welcome
you
Muffin
can't track
Tots.
the phone if it's off. You can't track it. We all learned. If you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged. And when there was talk
There
of
was a
them being
mob
charged.
literally after them.
He talked to
You
you
crazy
about
woman.
the scene at Oxford.
Hey,
High School.
Marissa and Nat Jung. Welcome.
And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about.
Farrell, are we up to 3? I think we're up to 3 times the kids' names have been mentioned. I didn't hear any more than that. So I think the poll is still going.
Way before you
For
get to
the for the all of them.
You
Like
sometimes
she's
have to
mentioned
get
a
the
name here or there, but
job
for
Yes.
the
to
listing of all
go
4 is
where
3.
the evidence leads you.
I still say there's going to be
And
4
there were
total.
things about this case
There's going to be
from
one
the
more
very
right at
beginning
the end.
that
Well, that's
just
it. Like I'm like, oh man, we're at 3 in like 3 minutes.
I know, real quick.
I
Yeah.
thought she was gonna theme the
was
whole thing
purchased
and
4 days
just say their
earlier
names 400
by James
times
Crumbly, who
and
was
end
the
it
same
with
person
say their
who
names.
was at the school that day. This is information they're learning immediately. They do a search warrant
Oh, for
the
sure.
house and for phones, and they find out a lot of information. You saw the video of the shooting. There's
I should have put a timer up for her closing.
We don't want
How
those
long ago did she
images
start?
out there. We don't want them to be on the internet.
Probably
We don't want to encourage another
40-ish
school
minutes
shooting.
ago.
And we don't take any pleasure in showing it to you. But it's our job to know the truth.
39
and look
minutes
at it
ago she
and not
started.
look away.
Yeah, that's pretty good. I said 40.
He told you
Hit
how
the
you
like
should
button,
fix
share
that.
on socials, this stream.
Hannah was hit immediately after he left the bathroom.
She's going to go through them all.
You saw the image and it was described
Wait.
to you. Madison Baldwin
Yep.
didn't run.
This is going to be 4.
She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in her head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately.
Oh.
She went into the
We're
bathroom.
at 4 now.
Stayed there.
Yeah,
Justin
we
knew
got
the
4.
shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbly's son shot Justin Schilling, execution style.
We just did one, Christine.
Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection and you heard during opening, and if my prediction is you're going to hear it again.
And again.
There,
and
I put it
again.
in chat
That
for
this
you,
could
Farrell.
be you. This could be any of us. This is what defense. This is their defense. That this could be you if you let your kid drive a car or
Yes.
leave with a sharp
Oh,
object.
she's been listening to us.
This couldn't be everybody.
She
This
probably
could be
sits
the
at
person that
home
takes
at
the
night and
kid
watches your
This couldn't
recap.
be the person
I
that
know.
buys
Hi,
a
Karen.
gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car.
My system.
Beware of the claim.
Do you have to work with
that
her?
This could be you.
Yeah.
Beware.
That
Oh,
work with
that'll
her
be
all the
fun
time.
next time.
It is
I
not the
just
case
resolved the
that
case
finding
before.
James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself.
But see, you don't object from a defense perspective because you want to make that argument, and the argument from the defense is essentially jury nullification. And so now that the state has brought it up in their closing, they can't
Right.
object. So
This
you're
could
like,
be you.
okay, yeah, I'm gonna be like, this could be you. I'm gonna say it all the time.
This
in a
could be you,
courtroom
and
being
it doesn't
charged with
have to
involuntary
be
manslaughter.
a pew pew.
It is just not the case,
Mhm.
and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbley. We know
Yes,
that
they work
Caltech
together.
was
Does
left
Karen know you know?
out,
Oh,
unsecured,
know you.
with ammo.
Oh,
Why do we know that?
no.
You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber and the safety is off because red means dead. And Special Agent Brandon told you that.
Oh my.
Even if James Crumbley
Wow.
was standing
This is
next
the
to his
if the
son,
glove don't fit.
that would still be an
Red
extremely
means dead.
dangerous way to handle a firearm.
So dramatic.
But we do know what happened. Because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else.
Oh, she's
All I need is
unzipping
an
slowly,
hour.
huh, young?
Later pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun.
Hey, Peter, eh?
It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have
I
access
canceled mine,
to
Peter.
and the ammo.
And
I
then
canceled it for you, Farrell.
I
have
canceled it.
access to the gun.
Then the Midwest Guilt hit and I rejoined.
Then we have defendant's own statements. James Crumbley said it's a substation.
You're like a bad gym
James
membership.
responded
I'm just
when it
gonna
asked
be a
where the
member
gun was. It
till
was hidden in our
I
armor
die.
in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked. Never says it was inaccessible to his son. And again, never says
Ethan says it
or
was
expresses
hidden.
any surprise on how his son got a hold of it.
Ethan, in his own words, said his
Right.
dad hid the
You know,
gun
he
from
took him to
him.
the range. We showed you videos and images of that. In fact, 8 times.
And the ammo. Didn't
we
he
know that
say
happened.
he had to find that too? Or he had found that or something?
We know that throughout
Gun and
June,
ammo
July,
were hidden
August,
from him,
September,
I believe.
October, by November, when he begged his dad for the 9mm,
That's what they
and he
do,
actually
Jen.
did buy it for him,
Yeah.
now
Kids
he's
are
at the point where
manipulative.
he can instruct other people. It's James Crumbly's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbly taught him. He didn't take himself to the range with his dad. This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that.
Not at the
bedroom,
time of
in
this,
the, in
no.
the defendant's bedroom,
They passed new laws since, but not
interlocking a safe.
not in November of 2021.
In the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the
So
other
why-
important thing
why-
is you're hearing a claim
What's that now?
that James Crumbly didn't think that he had to
If it
lock this weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2. Special Agent Brandon read to you the lines if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32
Is number 5
shots
coming up?
fired that day by James.
could have
Crumbly's
prevented
son.
it. Come on, say
No.
the names.
How do we know this was foreseeable?
I've only heard
The
the 2
shooter
or the
says
4.
in his journal, I have zero help.
No,
for
I
my
said,
mental
is it
problems,
coming up? I
and
mean.
it's causing me to shoot up the fucking school.
Yeah, she's got to do 5 because
Listen,
she did
Gary,
carries
We're
with
on
her.
YouTube.
I'm
You
hearing
can't say
Gary
those
Selection opening
things.
about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal.
Young's out here.
because
Wrap
he's
it up,
exaggerating
Karen.
or lying. We have the text
Jung, you don't work
between
right now. Cancel your appointment.
James Crumbly's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually told my dad,
It's been
asked my
50
dad to take me
minutes.
to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and
What
sad.
Jung said, and that's
Ah.
why I say
Wanting help.
we needed an expert.
I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911.
If he opened up to a therapist, maybe.
This was in April. But then my parents would be really pissed. I'm going to ask my parents.
Everyone
to go
gets
to the
mad at me
office
when I
tomorrow
tell them
or
that I go
Tuesday
through my
again.
kids' phones, I go through
But
their
this
text
time I'm gonna
messages, I
tell
go
them
through
about
their
the
journals or
voices.
whatever else they've written down.
And
How
then
can you
on
do
April
that?
5th, like I am mentally
But you have to know that the journal even
physically
exists if you're gonna.
Well, that's true. Usually I stumble across them. I'm like,
What
oh,
did
what
James
is this? And I
Crumley
start
know?
flipping
Oh,
through it.
He knew
I
the
was
family
just
dog had
cleaning
died,
out your
the
sock
grandmother had just
drawer.
died.
Oh.
His son's only friend, the one person he had any social contact with,
But I don't allow them to have
abruptly leaving,
Snapchat
can't
because I
even
can't go
text him.
back through and review everything.
Knew his son was completely isolated.
Listen,
Knew he had looked up bullets the day
many,
before.
many, many moons
Knew he
ago,
was
I was
upset
a
the night
teenager.
before, knew he had been watching videos that
Oh,
morning.
I might need to
violent
jump
videos,
off.
And
Hang
then
on.
he sees that drawing. He sees that drawing that morning when he goes to the school. And what does it say? It says, help me. How many times does this kid have to say it? He says it in his journal. He says it to his friend. And what is he saying? I asked my parents. I asked my dad. And then if that isn't enough, he writes the words, help me, on a piece of paper. And his parents, James Crumley, is called to the school to see it.
I'm going to have to
And
jump
what
off
does
for
he
a
say?
bit. I'll be
He
back.
says, we got to go to
Okay.
work. He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier, he purchased that weapon for him. This is James
Exactly,
Crumley's son on the morning of the shooting, November 30th, being dropped off like every day by James Crumley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life
agree,
is
Ken.
useless. The world is dead.
Yeah.
This is the
I
worksheet
think
James
that
Crumley looked at when it was texted to him.
Internet
This
interaction,
is the worksheet he sat and
checking
looked
up
at
on
when
is
he
one
sat in
thing,
that
but
counselor's
reading
office.
private journals is totally
Those
different.
are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths.
That's it right there, Wicked. If he was screaming for help, why didn't he take it when it was right
James
there
Crumley
in front of him?
Failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have. Could have driven around with him. He could have not done any DoorDash round until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his door dashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack, never thought then to say, hey, can I talk to you out in the hall? Or, hey, where's that gun? Didn't ask his son where that gun was, didn't check the journal, despite acknowledging he had one. Didn't lock and secure ammunition, didn't lock or secure the gun, didn't take his son home. Didn't take him to get this care that a counselor's telling you he needs. Didn't say, we bought him a gun 4 days ago as an early Christmas present. And didn't tell the school much relevant information at all. And Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumley was concerned about it. James was always home. Is he home yet? Is he home yet? Is he home yet? Leave me alone. I have to work. He's fine, is what he says. The incident about giving him melatonin and him being worked up. Didn't tell him that he'd asked him for help and asked to go to the doctor, told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with, that there were multiple guns in the home, that he was begging for a 9mm. James Crumley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. And that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for one day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with his gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock and all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37, he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where the unification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meijer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter. And it was James Crumley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency? Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please. Okay, I'm not going to be able to send anybody to your house right now.
Right, Vodka? You don't know that he was the only parent that thought, oh, crap.
I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a tax paper, and then I was down, and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the high school, see someone going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. Okay, and I think my son took the gun. I don't know. I don't know what's going on. He's really freaking out. I'm just naming Ethan Crumley, Crumley. You know he was. Sir, I'm going to put you on hold for just a second, okay, Mr. Dr. Cookman, come in and see if I can do anything for you, okay? Thank you. Okay, then.
Yeah, but that's not what she said, John. She said he's
You
the only
just heard this.
one
I
that
have a
thought
missing gun.
that.
My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he says, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on
Yes,
this morning,
because he had the benefit of
and
hindsight.
words on paper that says, help me, blood everywhere, with a picture of the gun he bought him.
It's got to
So
be
I raced home and I
foreseeable,
found the gun
not in
missing.
hindsight.
We went into detail about what James Crumbly and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he receives it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think he owed something to the parents and the kids in that school to at least
But he
try,
pieced those
once
two
he
things
did figure
together,
out
John.
that he actually, the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid.
He didn't, after the
Doesn't get in
meeting, he
trouble.
didn't go home and see
Yet he
if
was looking at
the
bullets.
pew was
They were
gone.
called to the school, and the drawing, he doesn't say that, or what the drawing was really about. It's a downplaying situation. And then he says
If he would have went home and checked for it
again,
before
never once.
he
I
got
don't
word
know how
that
he
there
got
was
it.
active shooter, I would
Never
say
once
different.
says that. James Crumbly had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing. And we know that because we know what his response was when he received the drawing. He kept those concerns private that morning.
So
But he
choose
didn't
a
just
mind reader.
fail to inform the school. He failed to act. James Crumbly failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son.
That's probably
He
true of
failed
most
Tom.
parents, John, but if you have a kid that's
He failed Madison,
doing
He failed
things, you
Toots.
might.
and he failed Justin. He failed to perform his legal duty to prevent these kids.
That's
from
5,
being
right?
killed. And he failed their parents, Jeff. And I ask that you find him guilty. Thank you.
Thank you, prosecutor. Ms. Lehman?
Yes, Your Honor.
Here we go.
There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that that day had on them. Multiple people told you what that day was like. They told you what they felt. They told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others, and that James acted in a grossly negligent manner or breached a duty that he owed to other people, despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021, and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have 1 or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't, because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've
Right.
seen him. Judge Matthews instructed you at the beginning. James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't.
What you see in the courtroom
It's
is
just not
evidence.
What he was doing, and it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the
she's
time
wrong,
that his son
because
made
it
that
says
video.
that what you see in the courtroom
He knew
can
that,
be used as
that
evidence.
James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm.
He's
Was it
hard of hearing,
unsupervised?
Sunshine.
We don't know. Was it supervised?
And
We don't know.
they said he would have heard
We
Ethan
don't know.
screwing around with the gun.
So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw texts between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister, who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw James and his son, and saw no concerns, not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk, sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all, just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me, and I need you to tell them. That didn't happen. Instead, Mr. Hopkins,
I was going to ask that. See, did he hug him?
About the level
did
of
they ask if he hugged him?
Although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework.
Can I pause this real quick and get an update from you because I haven't been listening at all. I've been in court, as you can tell. What's up?
I think I didn't get to listen to all of the other ladies, but I think she's doing a decent job. She mentioned his being hard of hearing. She said you've seen him in the courtroom. You've even seen him have to push them in to hear stuff. Because she was talking about how the guy said, "Oh, he would have heard Ethan playing with the gun," and he did his little demonstration with the gun. And she's like, "You've seen him." And they objected to that and said that's not evidence. But what you see in the courtroom can be evidence, right?
Yes, what you see in the courtroom can be evidence.
Observed, yeah. So, and the judge said, like, I told you at the beginning that he's wearing hearing assisted device, so.
Okay.
But yeah, they objected to her saying that, but that didn't go anywhere for them. But she's doing good. She's
loud
going
enough?
over.
I'm just realizing the volume was turned down, unless I just did that.
Oh, I don't know. I wear earbuds, so it's usually fine for me. But she's going over different things that can be reasonable doubt. Like if they didn't show this because it didn't happen. That he didn't care about his son's mental health, that he knew that Ethan had access to the weapon and was playing around with it and things like that. They didn't show these things because they never happened.
Okay. All right. We'll keep playing. I'll keep listening.
So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself. More than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, "My son was a great kid." I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that.
I hate that.
But Christy Gibson Marshall also said that James's son was
awkward.
A good kid.
What ruling is that?
Christy said that.
Not saying Ethan.
Her testimony.
Oh, I know. Yeah, it's really weird.
Awkward.
Was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun.
If hearing the word Ethan is so triggering, maybe trials are not for you.
Even in those moments. going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they believed that James and his wife were going to get their son help, that they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask.
I think they're using the excuse that he's a minor.
That James's son was a danger to anyone.
But it's just an excuse.
Yeah,
despite the information and the concerns that they had, they made decisions
ridiculous.
with the information that they had at the time and based on their education and training, which we can all probably agree, a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was an immediate danger to himself, because if they had, they testified they would have done things differently.
Yes, John, that's what I'm saying. In court,
James works. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back to the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know.
Yeah.
He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights. He saw multiple police cars. He followed them. He actually tried to go to the high school first, and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home, he found a gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Mick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on.
That's hindsight.
You heard from James
not
2 more times
stability.
within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no. Let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbly. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbley say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge.
Which is what she
that
should
his
have
son
said
had
on the
access to
stand.
any of the firearm.
Yes,
When they were
Jennifer
asking if
screwed
she
herself.
if she would have changed
You
anything.
saw his son's own words.
Having
Sometime after November
regrets in
27th
hindsight
of
is not the
2021
same
and
as knowing-
before November 30th of 2021. And we know that.
You know, knowing
Because
the future.
in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbley had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Cal-Tech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines. And she responded and said, give him a hug for me. She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and heard testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Miss Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Kel-Tec. James indicated, per Miss Back, that he'd been looking at the Sig Sauer for a few days or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the .22s, but James didn't purchase 9mm ammunition before November 30th of 2021.
Last time.
Cammie Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on. And you can imagine, I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that. Because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now,
That's good that
Your
she was able to get James's statements in that he would have taken him home had he known without James testifying. That was good.
Yeah,
I didn't
that's
catch
what
that
John
in
said.
the-
She's doing a good job of testifying for him without putting him on the stand.
If
She's
Jung
sneaking
said
it in
that,
there
Jung is
very creatively.
absolutely, yeah, no, that's very good. Yeah, he didn't need to take the stand then. So, no,
Yeah.
that's very good. I like it.
every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt based on the evidence that you've seen, the testimony that you've heard, your collective memories. You can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial.
I like that wording.
Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the 6 hour. You just saw in his journal that he said he had access, but you don't know how that happened.
Did she show
No one
the journal
testified that the
entries?
shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used
Not that I
on the
noticed.
gun safe with the Keltec and the 6 hour. There was no testimony that the shooter even knew about that code or what it was.
Thomas, I already have a cool looking hat.
You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son firearm safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. Think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I ask. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance. And I thank you for the time and attention that you've paid.
Yes, that is her name.
Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again, follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please follow the law. Review the evidence. Review the instructions. And follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt. And your vote will be not guilty. And your vote should be not guilty. Not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
Thank you, Ms. Lehman.
I liked it.
Rebuttal,
A
prosecutor.
little bit
I
that I
really
heard.
liked it. I like that how she told them to come up with their own reasonable doubt.
Yeah. I
Otherwise,
sped it up
they
for the
should put it in it.
prosecutor's rebuttal.
You know what my least favorite part of the trial is?
Oh,
It isn't
Lord.
listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My
Karen's gonna
least favorite
Karen.
part of the trial is that even where we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. It doesn't take it away. So don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence.
They're making
I
everybody
embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country, every single day of every year, for decades and decades and decades. That's the burden we have. And it is not,
I
despite what
agree, Moni.
the
I agree
argument
with Karen.
is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden. So I embrace my burden, but I'm not going to embrace something that's just not true. Because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove.
That's not the
Yeah, please spank me harder.
The judge is going to instruct you what burden is a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements and what are the elements. You're not going to hear that the elements of this crime are the.
So the question is that true? Now, if you're asking me if it's true that she would charge them with murder if she had proof, absolute proof that they knew, I believe that to be true. Yes. However, for it to be murder,
and they should, if they knew that he was doing this.
Well, but the thing is if they knew that he had a mental health issue, and that's what she said, like in the first trial, in Jennifer's trial, if they knew that he had a mental health issue and still allowed him to have access to a firearm, they would charge him with murder. Oh, no. It was specifically to the journal. If I knew that they had read that journal, then I would have charged them with murder. You still have to have the intent, right? So I don't think that rises to the level of intent. But do I believe that she would have charged him with that? Absolutely.
That's what I was saying, John. That's what I'm hearing her say right now is I didn't prove my case.
Yeah.
Saying it's not my burden sounds like she fell short.
Yep.
I have to prove what he knew. What he actually.
I will say she's at 0.25. So if she sounds a little unhinged, I sped her up.
They knew. That's not the law, ladies and gentlemen. That is not
okay with
the law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove. There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbly went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked.
She is struggling.
She's like, I can't read my own notes.
Defense counsel put up a statement from the journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not going to go through every single thing that Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. And the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because I'm in
now she's giving a TED talk again.
That's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense because any reasonable person, which is the standard you have to use, using ordinary care, would know that because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But
No,
you
he
do
did
know
not
that
testify.
whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to make this, to prevent these deaths.
No.
And you are hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around. My dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting the cable lock.
Jamie.
Hi.
Hey, mean girl.
I'm getting
That takes
mad.
less than 10 seconds.
Uh-oh.
Takes less than 10 seconds.
Please
Hang on.
don't beat me.
10
Unmute
seconds.
yourself so I can edit your
You
mic.
don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds.
Well, she opened it now.
Yeah.
She's disturbed evidence. She's altered
Let's talk
evidence
about
because it was
the
in a
gun being
sealed
hidden.
package.
Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. Those are the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew the guns were kept in the bedroom. This is where he says he hid the gun, the armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was
Maybe
in the
he went through
armoire
it.
under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was because it wasn't. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not
Kids
the
are going to
case.
find stuff.
But
Reason and common sense is what we have to use.
But she just said we have to believe everything that's in his journals. So
We know.
Ethan said the gun was hidden.
That James Crumbly went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability. And that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids
And
doing
it is
kids
about both.
things.
You're making it that
The
way.
kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were
Mentioned
dancing
them
in the
again. Did she
hallway.
mention
Those
them
are
at the end of her
kid
closing?
things.
Oh, yeah.
Parenting
What was it?
is the
5
hardest
was
job
the total.
that we'll ever do.
5 was the total, so now
The
this
hardest
is
job and one of the most important ones, but it's exhilarating and joyful.
No, this
The
is
best
7 then.
experience of our lives.
Because she said their names
We
at the
look at kids when
beginning.
they're born and we see hope,
okay.
but they can break your heart. They're supposed to.
Do I still have a
They have to
poll
leave
going?
someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and that it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution, in this case, is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't, in a very limited way that the law allows a parent to be charged.
I can exist in both worlds, vodka blood.
Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You listen to all the evidence, and at the end, you will conclude that James Crumbly failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove.
Did he hug him?
And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day, because if James Crumbly had done even the smallest of things, like the 10-second cable lot, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keese and I, the people of the state of Michigan, have met the burden to find James Crumbly guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
I have never heard someone say so many wrong things, one after the other, consecutively in a row.
You're going to get a copy of these
I was
instructions.
thinking of the defense lady
Members of the
said them
jury,
once.
evidence and arguments in this case are
Say
finished.
that again.
I'll now instruct you on the law.
She said them 7 times. The defense attorney said them once. I was thinking of her closing.
Based only on the evidence and the instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced.
If you are a member of my channel, then you get access to the Discord, which is under the member tab. So you first have to become a member. And then once you get in there, Jung will show you around, or Jamie.
This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any facts in this case is fine.
I know. She's like, I'm
It's
out.
my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law,
All right, we've all heard the jury instructions over and over and over. Jamie, what are your thoughts?
Can you hear me?
Yep.
I was away from my phone. I loved the defense this time around.
Yeah.
She was much better. I just like all the little things where she was just hitting all the points of like, he didn't know this. He didn't know this. Like where did they show the evidence that he knew this? And but then Karen comes in with her just BS argument of this isn't about guns and it's not about emotion. It's not about these kids were just living their lives and James just ruined it. Like, ugh, just.
So it is
right, Sean.
it is
At least
3
you didn't
o'clock.
bring up CP.
Yeah.
It is 3 o'clock local, so the jury's probably going to get this around 3:30ish. By the time we go through the jury instructions and they get sent back, and then so that gives them about an hour to deliberate. They're not going to get a result today, probably. So I would suspect maybe sometime tomorrow, but I'm not sure. I have set up a verdict stream, which is not going to go live until we actually have a verdict. If there's like an interesting question, I might talk about that. I might go live on a different stream for jury question or something like that. But That's what we got going on so far.
Okay.
And look at
kinda
that,
weak of you,
Ashton. I am retired. Ashton
Can I-
became a new member. Awesome, thank you.
Can I ask you? I see people have said this before, and I kind of see a comment in the chat. Like, how do you feel about people that would be afraid to vote not guilty because of society in that area? Like,
Cowards, but most people
that's what
are
I mean.
sheep and will go with the herd. Unfortunately,
Because I find that so despicable, to be honest with you.
Yep.
yeah.
You really should. You
Have a
shouldn't be. You
backbone.
shouldn't have to worry and give two craps about what anybody. If you believe that this is not right and you're standing up for it, regardless of what anyone has to say, you should.
Yeah, but there's very few people that would be willing to do that.
I don't get it. It
I don't
bothers
either.
me, especially in cases like this, because I get it. You are right. Like, there's mobs out
What's
there.
that song? Ticky
If you don't
Tacky.
stand for something, you'll fall for it.
Oh,
Well,
that's very
that's
true too.
Nobody's willing to stand up and say, no, this isn't right.
Mhm.
Well, didn't you say that people were making comments during jury selection, like the voir dire, that they would be afraid to?
Oh yeah, some of them did. They would be afraid as to how their not guilty vote would be seen by friends and family, and how they would talk about it and be questioned about it if they acquitted Jennifer. I didn't sit in on James, so I don't know if those issues were
Oh.
brought up, but they were definitely brought up on Jennifer.
Yeah, so I don't think it's John Gary. It's really about, the police, but these people are feeling that way too, and I think that's such a coward way to be.
Chris Mullen gifted 5 memberships, and those went to Mamasaurus Rex, Heather Mauser, JL, Dory K, and Cheryl Robertson. Look at that. I'm better with names now that I'm retired. Thank you very much for the gift of memberships.
You've been studying?
I've been studying, yeah.
Is that
At
what you're
night,
doing
I
with all
just
your free
rehearse.
time?
Yeah, I just rehearse all my name
You just go through your
pronunciation.
sub list.
Exactly. If you are a new member, click the member tab on my YouTube channel. It'll take you to a link to my Discord. When you get in there, you will be placed in a waiting room. Let Jung or Jamie or myself, or most particularly Farrell, know what your YouTube name is, and then we'll grant you access to the
Listen,
rest of
I'm
it.
leaving that Discord.
Read my post, please. Oh,
Oh,
my
yes.
God, just repost it, Jung.
You're in trouble. Listen, this is what happens when
I
you
got.
retire.
How far up do I have to scroll? There we go.
She's
All right.
got to lump it all into one stream now.
Thank you all for being here. All trial chat. You all held the chat together and going so Dave could jump in and out and play attorney in real life. Yes, I appreciate that. It's been fun, actually. So this might be a new thing where I stream
I was going to
trials
say, you're going to
without
do some of this
commentary.
then?
Yeah, I actually
Good,
I
then
might. I know there's a
Can
no
stream
body
snipe
case
you
coming.
more?
Yeah, why not? So, I don't know. I like
don't know
doing
about
it.
that.
I
That
just sort of
kinda-
sit
maybe in the
behind here.
afternoons.
Prosecutor needs to prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement.
We have them in my Discord, and we heard them all before, so that's why I was ignoring them. But we'll listen.
You must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There's been some evidence that the defendant ran away and tried to hide after he was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talk to one of the witnesses. There's nothing wrong with that. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony would be. You've heard testimony from witnesses Detective Edward Rogowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about the matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether these facts are true. You should also not think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and the ammunition by his minor child. Second, in doing the act that caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count four, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Justin Schilling. That is, that Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. In count one, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In
They'll
count two,
probably
the
reach a
defendant is
verdict
charged with the
tomorrow.
crime of involuntary
Sean
manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Tate Muir. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that causes an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Tate Muir was directly caused by defendant's failure to perform this duty. That is, that Tate Muir died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Hannah St. Juliana. This legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control.
So basically, they have to know that there's a reason that they have to control their child. So they have to know that he suffers from some sort of mental health issue. And they have to know that there's an opportunity to actually exercise the control over the child, which is a weird standard. But you have to basically prove 2 knowledges by James. And I don't think they meant even 1.
Yeah, they didn't.
Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. As I explained to you earlier in my instructions, the prosecutor asserts 2 different theories, to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because he failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because he was grossly negligent. Those are 2 different theories and 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It is not necessary that you all agree on which theory has been proven. As long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. There may be more than one cause of death. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I previously indicated to you that it was my order that the shooter's name not be used during the trial. When you go to the jury room, you'll be provided with a written copy of my jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement.
Are we going to have Vampire for a jury foreman again?
Oh, Lord, I hope not.
I posted in my Discord. I was just randomly searching through Facebook with the Crumley's name, and there was a woman who said that she was juror number 3 before she was discharged on Wednesday, and then so she's got like a picture of her with a jury tag, and then now she's on a train trip to Chicago and stuff. But she looked a little, and then I started going through like her entire Facebook account, and oh my God, I'm so glad she wasn't on the jury. I don't think she'd keep her own life together. Although it might have been good for the defendant. I don't know. She was just a little.
Instructions that arise from the deliberations. You should write a note, and you can give that note to my clerk. Possible penalty should not.
Text messages regarding the demons. Did they come in? See, this is the one downside.
If you want to communicate
to not watching the trial the entire time, I don't know if they came in.
It's not proper for you to talk directly with me, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone.
Yeah, you know what? I think you're right, because they were from Ethan to Jennifer. And so since this was a James trial, the only ones that came in were between Ethan and James, or when they were in a group chat. So you're right. So those didn't come in either. This is fundamentally a better case for James. Actually, it's to James's favor that this case was bifurcated, I think.
But I think I told you this in the beginning of the trial. If you want to rehear someone's testimony, you have to rehear the entire testimony, all of the questions from both sides. That's the only
I can
way
play it
that's
for
done.
you, Judge.
All
Just
right?
let me know.
But we can replay that in the jury room. As you discuss the case, you should think about all of my instructions together as the law you are to follow. The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately in light of all the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I've prepared a verdict form. It's pretty self-explanatory. It lists each of the counts, and this should be filled out by your foreperson. Count 1 is involuntary manslaughter as to Madison Baldwin. You can either check the box not guilty or guilty of involuntary manslaughter as to Madison Baldwin. As to count 2, involuntary manslaughter as to Tate Meir, not guilty or guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can either check not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling.
My mom just texted me. She said, I heard the school had a gun shooting club. Like, oh my God, if they, I don't know, but why did that not come up?
All right.
I thought
I know you've been to
Nice.
2 different jury rooms.
I did like how the dean of students in Jennifer's case testified that there's a lot of kids that pose with guns for the homecoming photos and stuff.
Yeah.
Right? Yeah.
That didn't come up in
Graduation
this
and
case, though.
homecoming.
Yeah. And they got the merging of the tribes, right? So we're going to put you all in one jury room. We had you in separate jury rooms.
I mean, it's not uncommon back home either for senior pictures
I
and
appreciate that you were all here the entire time. Jurors have different feelings when they're excluded from deliberations. Some people
All
are
right, so we're
happy,
going to
some
get
people are not
2
happy.
alternates.
I can tell you a lot of stories about, life happens, so
will she
all of your
dox them?
service is important. This is obviously very important.
No,
Very
she's not Schroeder.
stressful, to both sides, and we couldn't conduct this jury trial without you. So we are going to exclude 3 jurors by blind draw. Okay?
I would be so mad. I would be furious if I sat through a whole trial and got excluded right at the end.
I would too. I'd be like, no.
Let's stand up. No.
I'm going to try.
Draw
I've
again.
reached out to Shannon. I've actually emailed with Shannon a couple of times, but she's still under the gag order. Is it still called a doctor when he doesn't use gloves and he's Asian, Jung?
Jury in seat 5, you are
What?
in my jury room, I believe. Do you have any personal
Yeah.
belongings?
Prove it.
Okay, I'm going to ask you and the other 2 jurors that we're excluding to get your personal belongings.
Shit, I missed the jury. What was it?
All right.
Hang on.
You and the other witness seat 5, you are in
5.
my room, I believe. Do you have any personal belongings?
That might be
Okay,
good.
I'm going to ask you and the other.
Based on what
jurors, that we're excluding
Mavic
to get your
has
personal
said.
Belongings and come back in here, all right?
5 not a good one. I don't remember.
No, 5 was like super antsy and taking a lot of
Jury
notes when the
C10.
prosecutor would talk,
Aw.
and not when the
Jury
defense would
seat
talk.
10, you are
Jury in
in
seat
Judge
10.
Anderson's jury room,
10.
the second jury room. Do you have
5,
personal
10,
belongings
one
in there?
more.
Okay.
Oh yeah, she was also the one that was really crying hard.
Good.
And you're
That she's gone.
in seat 15.
15. Okay,
Right,
I don't know
actually,
anything
why
about
don't
10
I
or
ask,
15.
The 3 of you to get your personal belongings from the jury rooms, and then go with Miss Nella to my chambers. All right. So you'll go to the jury room that your belongings are in, and come out into the hallway. Miss Nella will escort you into my chambers. All right.
Yeah, Jung, did you ask him why? Take your pants off to have your face looked at?
Oh my God.
Jung's having a good time.
Okay, so do some of the jurors here, anyone 9 through 15, do you have anything in Judge Anderson's jury room? Okay, I'm gonna let.
None of
these
them are
jurors
old,
go into
Lefty.
my Chambers. And then anyone 9 through 15. if
No,
you
I
have
don't think he
something
means
Yes, I
those
do,
blue
Vince.
hairs.
Jury room, then you're gonna go to my jury room. All right? Okay, so I'm gonna give them a few minutes. Also, after you go back there, I'm going to ask you to wait a few minutes before you start deliberating. I want to consult with the lawyers to make sure the jury instructions are correct. Sometimes things are left out or there's mistakes, so I just want to make sure. I also want you to know that we're now on your schedule, so what you say goes. If you take a 5-minute break, an hour-long break, whatever you do, we will.
Oh, you're talking about the dyed blue
There's
hair?
potentially an
Not that I'm
opportunity
aware
to
of.
go later tonight if you want to do that. I want to encourage you to take your time. You can come back tomorrow, you can go later today, whatever you need to do. We want you to be careful, keep an open mind, and take your time. Right? So I'm going to wait and see if those 3 jurors are in my chambers.
None were reported, but none were reported last time either.
Yeah, Haley, she probably is. Oh no! Well, who put that number in the box?
It's not here, right? Yes. We try. It's an old building.
It's not that old of a building. Well, there was no screaming and yelling during this trial. There was no temper tantrums and stacks of papers
All right,
falling
so if you
over.
can
And
all get together in my jury room, I will send jury instructions in there shortly, and then you can start deliberating. You can't deliberate unless you're all there, so. Okay.
All right, for the jury.
we did have a vampire witness. That's true.
Oh, sorry.
We did get a little yelling during the closing arguments. Fair enough. If that's what you're referring to. I'm just going to assume you are. I know. I'm going to go run around outside. I've had the door open all day. It's
There
been
is
nice.
one error in the jury instruction on 4.1. At the end, it talks about in deciding if you believe the defendant's testimony
I
before. So I'm just going to
Yes,
take it
Judge.
out.
Thank you.
All right, anything else about the jury?
Oh,
Nothing
there was
other
no
than-
Swifty lyrics.
All right.
No Swifty lyrics.
Bummer. No CP, no Swifty lyrics. It's like they're not even trying.
I'll be here then.
Okay.
We will be 5 minutes away, I promise.
I think Lee is asking for a copy of the jury instructions, which I'll provide if you both agree. If you don't,
I have no problem with
No objection, Your Honor.
all right. Anything else? Oh, you're going to give me all the exhibits.
that. I have them here.
Okay.
We have the exhibit lists with redacted portions for any exhibit that was not admitted.
Okay.
And first two.
Yeah.
All right. That's about it. I don't see anything else. Jamie, thoughts, feelings, emotions?
I mean, I feel like his case was a lot better than
Yeah, I do too.
because a lot of the, I think keeping a lot of that text messages out was great because obviously it was Jennifer, not him, and I
Right.
think his lawyer was so much better.
Yeah, she was.
And
She
there
was
because
more in
the
control of
cattiness,
herself.
I think, probably didn't help for Jennifer. The cattiness she was doing all the time. I mean, it was funny for us, but
Yes,
I was
sir.
a good.
Thank you.
It's
Yeah.
not. It's not a good. It wasn't the case to be funny at. To be like, to have that shit go on.
Exactly.
Yeah, and you could say that this attorney has had a preview of the state's case, but a lot of it was testified to at the prelim, and they were both there, so they've had a preview of this.
Yeah.
I just think it's Shannon's
But
style.
she handled herself better.
Yes.
She
Yes.
was professional, and the other one seemed very unprofessional at a lot of moments.
Her arguments were so straightforward, and I don't know. I just liked her demeanor better.
Yeah.
You didn't have to hear. I mean, don't get me wrong. I didn't mind Shannon's closing argument, but not having to hear me and my kids and the things I would do was so refreshing.
Does she not even have kids? That's what I heard. Was that was made up?
And she has kids. I'm friends with her on
Oh,
Facebook.
okay.
I've seen her kids.
Okay. Well, somebody said she doesn't even have kids. She
Yeah,
was
she
making
does.
up all that.
No, she has kids.
Oh, okay.
I mean, I don't know how many and how.
I
old
mean,
they are. I
whatever,
wasn't
but-
counting, but I mean-
I'd make up something for a closing argument if it helped my closing argument, I guess.
on
but-
Facebook, it appears that she has kids.
And I just, for some reason, I just feel so bad for him. He looks so sad.
I'd
Yeah,
love
he's very
to see it
sympathetic.
not guilty for, yay justice, but mostly because then Lefty would be wrong about something.
I know,
I'm
right?
here for that.
I am so here for
I'm
that.
always for Lefty being wrong.
Wait, oh,
Yeah, exactly fed. The whining and the
It's very whiny.
he did was so refreshing to not hear. I did
Let's
Christmas.
see.
I liked her closing. I just, when I look back at it, I'm like, oh, this was so much better.
So again, for those of you who didn't hear before, I'm going to have a verdict stream up. Oh, it's already up, but I'm not going live until we have a verdict. If the jury has questions, depending on what they are, I might stream them in a separate stream. But I'm not going to sit and hang out.
So make sure you
and
hit the notification bell.
Yeah.
Yeah, go hit the notification bell. Oh, that's it. Okay, we're done.
And jump in on the Discord if you're a member, and you'll get a live alert.
Yes, as soon as Farrell figures out how to post live alerts, you will.
Sir.
Jamie, how have you been? I haven't talked to you in a little bit.
It's been crazy.
Have you gotten the computer I gave you up and running yet?
No, I got it. Why does that make me laugh? Because I was just thinking about that the other day.
I was thinking I'm going to need to give you a monitor, a keyboard, and a mouse, and maybe then
Well,
we'll get
yeah.
it up and running.
Why didn't you bring that down the first time?
Because I don't have an extra one. It would require me purchasing them.
Here's a box with some wires in it. Enjoy.
Oh, yeah. I heard you were mean to Baker, too, today.
That's what I heard.
First of all, slander. Apparently, his mean joke about me being mean is people think it's true. And I'm like, what?
You have been
It
kind
is
of mean
true.
lately.
Oh, stop
You should see what
okay.
she charges us to stream for her.
I know the judge said that the jury can stay late today, but I don't feel like the jury's going to want to. The jury's going to wrap up around 4:30, 5 o'clock, and they're going to want to go home. So that's only give them, like I said, they're going to be back there and start deliberating around 3:30, which is now. So they'll have an hour of deliberation. Then they'll decide that they're just going to go home. I hope they don't come back in an hour. That would be a shit show. But so we probably have a verdict sometime tomorrow afternoon. I'm going to predict 2 o'clock. So that would give them,
You think so?
6-7 hours of deliberation, something like that. That's my guess.
Do you really think it's going to go that way?
Guilty?
Mm-hmm.
I hope it doesn't. I'm concerned it does. If it goes beyond tomorrow, if it goes into Friday, it could potentially be a hung jury if it goes late into Friday, because that would be 2 full days. That would be 16 hours of deliberation plus a little bit today. But tomorrow after lunch, yeah, that's what I say, John.
Yeah.
Tomorrow after lunch, about 2 o'clock.
He is sitting in there, and they're like, "Nope, I'm not budging because this is wrong, guys."
I know. I'm so glad 5 is gone. Report we got. By the way, if you guys missed my recap stream yesterday, go check it out because Mavica, if I keep saying it right, is in the courtroom and joined me on the panel and gave a little insight. So, I mean, for whatever it's worth, but he kept noting Juror 5 was constantly taking notes, was disinterested in what the defense had to say, was crying during parts of the state's case in chief.
Mm-hmm.
So we were concerned about 5. It was the most animated. He said, but the other ones were very much like sort of resting bitch face. So who knows what they're thinking.
That was funny.
Yeah. Let's see. Nobody wants to end it Thursday and go back to work Friday. Yeah, but they could still say tell work and be like, we're still deliberating. I don't know what to tell you. I want a jury summons. I haven't gotten a jury summons since I was 20.
But then they'll just kick you off anyway. Won't they?
Maybe not. Maybe they'll be out of their peremptory by the time I get on the panel, and they can't kick me off.
I got one. Remember, I got one in January, and then I had to call every day. And
I was gonna
I
go.
know. I got one last year, but they never had any to go in on.
Yeah, they said no. You come in today. Call tomorrow. And they're like, "You're done." I'm like, "Aw."
Yeah, we do it for a month. I had like all of May or something like that.
Yeah, presumably this jury hadn't watched Jen's trial. They didn't see it. They also know the outcome though.
Mm-hmm.
However, there's a lot of evidence that was excluded during this trial that came in during Jennifer's, and there was a lot, most importantly, the journal entries that came in this trial that didn't come into Jennifer's trial, where Ethan said that his dad hid the gun from him. So things like that are a little different. So despite Jennifer being convicted, I feel like there's a good chance the jury could still say not guilty for James.
I know what I thought of now that you said that. Like when she was showing that, when they were talking about like, oh, well, he didn't try to hide the gun very well, did he? And going on and on and on about that. Like, to me, if you don't think anything's wrong with your child, that they're going to get of it or anything, like, yeah, you put it away somewhere, but why would you have to go like send it?
But
like,
was there a law that you had? There was no lockup, so he wasn't doing anything wrong by just having it in the cupboard.
Yeah.
Okay, so let's say this. Let's say you have alcohol in your house, and there's an alcoholic that lives in the house. Although there's no law that says that you have to lock away your alcohol, you probably would, right? Probably would lock it away. If you still wanted to keep it, you'd put it somewhere and lock it. You take extra steps, right? Because you know that this person is prone to get into it, right? So the same logic could apply to the firearm, that there's no law, but if you knew, you would have taken extra steps.
Yeah.
But
so
you
he
know,
has
again,
to
you
know.
have to prove knowledge. He has to know, right?
Because it's in the same aspect. If you have like, obviously my parents drank alcohol when I was a kid and I knew I wasn't allowed to get into it, so they would just put it up high. They would, or in like on a high cupboard, but I knew, you know what I mean? Like, so they knew like, hey, you are not supposed to be touching this or whatever. So it's
funny.
Like,
as a kid, I had easier access to my dad's firearms than the alcohol in the house. Because the alcohol was locked behind a key. The guns were hidden away, like in a really cool way, but you didn't necessarily, they weren't locked away. And I knew exactly where they were, and I knew how to get to them. Well, they weren't hanging on the wall, but you know, they were hidden, like hidden. But they weren't like in a safe or anything. But I could easily get to those, and I couldn't get to the alcohol because those were actually in a locked compartment unless I had the key.
In fact, we had one leaning against right next to the front door.
Yeah.
Well, there's like so much of that just makes me laugh, because it's like you can't predict any of this stuff, because yeah, like I think of like the 80s and 90s, are like my dad has like, you know, BB guns and shotguns just like leaning up against a wall, but we were told no, and no one thought any different of it. And you know what I mean? Like, I don't know, it's crazy times now.
Let's hear. First of all, no, but my brothers probably did. They said alcohol with water. Well, chat, I can say 3 women were not selected for the final jury. One being the seemingly very pro-prosecution lady that cried. Yeah, we noticed that, Mavica. I wrote it down and circled it several times like a madman. Juror number 5 is out. And 2 other women. Okay, so that actually evens it up. So the jury should be 6 men, 6 women then going back there, if that makes a difference.
Well, hopefully those men have some balls. That's all I got.
So
ladies, but
I'm going to go back to work now. Like I said, we have the stream coming up for Verdict Watch whenever we have a verdict. If we have jury questions, I'll try to go live with them, probably on a different stream. And yeah, so thank you, Farrell and Jamie, for joining me. Farrell's channel is in the description. So you guys can go check it out. She streams snipes me from time to time, and then she has other stuff she does too.
If you do more of these, we might do more afternoon stream sniping. It
just
was fun.
Be specific. I hate when you guys don't correct yourselves. Farrell usually does the Casey Anthony on Sundays. We're doing the Casey. I don't know if it's Sunday, but it's been every Sunday so far.
I have What the Hales coming on Saturday.
Oh yes, Lego stream with the Hales.
Yeah,
I'm looking forward to that one.
Yes. Oh, also,
I'm actually rewatching all of your Lego streams right now because I'm trying to find a clip and I don't remember which one it was in.
Okay. Also, I'm supposed to interview Solomon Anderson tomorrow for the documentary that I'm doing on Zachariah Anderson. And there was talk about potentially streaming the interview. If we do that, we'll dual stream it on Better Call Saul as well as this channel, but we're not going to be interacting at all with the chat because I'm trying to preserve it for the documentary. But you might, if we agree to do it, you guys might be able to see that. So just keep an eye out for that as well. And speaking of What the Hales, you guys are all going to be redirected to What the Hales rewatch that Legally Live is covering right now. So you guys can go entertain yourselves over there.
Go say hi to T-Bone.
Yeah, say hi to T-Bone for us all. And thank you, Jamie. You have anything to grift? Eyelashes coming up? You know, anything? Pedicure?
No.
No?
Nope.
Okay.
Not much.
All right. We'll see you all. Bye.
When I was young, my